Hi everyone, welcome. I'm humbled and grateful to welcome you all here to our fall conference. It's my first fall conference as the William P. and Hazel B. White Director of the Center for Ethics and Culture, and I'm very excited about what we have in store over the next 2.5 days. I think I should begin with an expression of gratitude to my predecessor and the founding director of the Center, David Solomon. In David's service, the Center, in his service, he created and sustained an essential, indispensable institution dedicated to the pursuit of matters that lie at the heart of Notre Dame's distinctive educational and religious mission. And we are all in his debt, and this evening is possible because of his vision and his friendship and his courage. Interestingly, this is the first conference, and this is the 13th conference that we've had. This is the first one where David will ever be actually participating as a speaker. And I noted that to him the other day, and he said it's because no one had ever asked him before. So I'm glad that we took care of that after 13 years. All of our work here, building on David's foundation, all of our work here at the Center is aimed at one goal, and that is to share the richness of the Catholic moral and intellectual tradition through teaching, research, and dialogue at the highest level and across a range of disciplines. And we believe that the Fall Conference as an institution, the Fall Conference now in its 13th year, embodies those aspirations in a positive way. It's meant to be a vibrant forum for dialogue and exchange for both elite and emerging scholars from a diversity of viewpoints and a diversity of disciplines. And we're especially proud of this year's conference. In typical fashion, we will be exploring a fundamental concept, namely justice, from a variety of interdisciplinary angles. A dazzling array of 46 speakers from around the world will explore questions of justice from the perspectives of philosophy, theology, political theory, law, history, economics, the biosciences, literature, and the arts. So given the breadth and depth of the disciplines and perspectives represented, the Fall Conference has been and will continue to be a truly unique event in the elite academy. But it's also unique because of the rich tradition of friendship and fellowship that characterizes this event. It's a great pleasure for me to see all the old friends that I've known over the years, all of David's friends, friends of the Center, and as well as new friends. We're grateful to Bishop Rhodes for coming to preside over our opening Mass. We're grateful to see all of our friends from the Congregation of the Holy Cross, students, faculty, and staff from a variety of universities and colleges from across the country, including, of course, our usual attendees from the University of St. Thomas, from the Wyoming Catholic College, from Baylor, from Rice, from St. John's College in Annapolis, Maryland, my alma mater, as well as a variety of religious brothers and sisters, the Nashville Dominicans, the Norbertines from St. Michael's Abbey in California, and many others. I'd like to express my profound thanks to the extraordinary staff of the Center for Ethics and Culture. That is Angela Engelson, Stephen Ferdoso, Tracy Westlake, and our student assistants, Angela Bermudez, Margaret Kennedy, Liz and Kate Everett, as well as Aaron Stoyle Mulholland. Let's give them all a round of applause for the extraordinary work that they've put in. Finally, I'd like to thank our generous benefactors whose inspiring commitment to the Center makes all of this possible. I would in particular like to recognize the Mays Family Excellence Fund as well as the Christy and Tony DeNicola family who have generously contributed to this conference. And before I turn to announce or to introduce my friend and colleague Bill Kelly, just two very brief administrative items. Your name tag that you've received, I'm told by my staff, is your meal ticket. That is, you want to wear that at all times. You need that to get into the meals. 5 minutes after meals have commenced, we're going to open up all release the open seats of those meals. So please show up with your name tag. Staff, myself included, have name tags on. If you have any questions or concerns or needs, please stop us. There are shuttle schedules, both to the Inn at St. Mary's and the Fairfield Inn, that will be outside and available for your use. The last shuttle tonight to Inn at St. Mary's is at 9:50. And the last car to the Fairfield will be at 10:15, just outside of the conference hall. So let me briefly say a few words about my very dear friend and colleague, Bill Kelly, who was kind enough to introduce our keynote speaker this evening. Bill is is, as I say, my very dear friend. He's an extraordinary person, an extraordinary scholar, an extraordinary public servant. Just to take a few examples, I mean, after finishing his clerkship on the United States Supreme Court, Bill served as Solicitor General, where he argued cases in front of the Supreme Court. He's worked in private practice. He's worked in a variety of public posts, including most recently as Deputy White House Counsel. And we are so blessed and happy, and I am personally blessed and happy that he has chosen to return to Notre Dame to contribute to its flourishing as an authentically Catholic, distinctive law school. And so with that, I'd like to introduce my very dear friend, Bill Kelly, who will introduce our keynote speaker. Thank you very much.
Good evening. Thank you, Carter. Although I have to say it is news to me that I was the Solicitor General. That would have been quite a young age at which to take on that task. Sometimes life presents opportunities that are pure and really undeserved pleasures, and the chance to introduce Mark Filip is surely one of them. Let me warn you at the outset, this might get a little tedious, but some people's resumes are worth taking a few minutes to recount. An additional word of warning as well for those among you who are prone to resume envy. Either you've had quite a career, you're subject to delusions, or you're about to be seething with jealousy. A native of Illinois, Mark Filip graduated from the University of Illinois in 1988 with the highest honors. He won a Marshall Scholarship and earned a BA with first-class honors from Christ Church College, University of Oxford. He then graduated magna cum laude from the Harvard Law School, where he was a member of the Law Review. He spent only 2 years in residence at the law school. His Law Review note, by the way, remains one of the most influential pieces of student writing produced by that journal or any other. Since student notes in the Harvard Law Review are not signed, however, you'll have to ask him if you want to pry the piece's title out of him. He's modest about that. After law school, Mr. Filip clerked for the great Judge Stephen Williams on the U.S. Court of Appeals for the D.C. Circuit, and then for Justice Scalia on the Supreme Court of the United States. He then joined the U.S. Attorney's Office in Chicago, where he prosecuted criminal cases on behalf of the United States from 1995 through 1999. He then joined the Skadden Arps law firm, where he became a partner engaging in both civil and criminal litigation. Throughout his career in practice and as a prosecutor, Mark also taught, including required courses in civil procedure and other important courses, as a lecturer at the University of Chicago Law School, whose website, by the way, referred to him as one of their most accomplished teachers, and the Northwestern Law School. In 2004, at age 37, Mr. Filip was unanimously confirmed by the Senate and appointed by President Bush as a United States District Judge for the Northern District of Illinois. 2 years later, he was named the best district court judge in Chicago in a survey of the Chicago Bar. In 2008, he answered again the call to public service, agreeing to join the Department of Justice as the Deputy Attorney General, the #2 officer in the department. In that capacity, he was responsible for supervising the 93 United States attorneys across the nation and managing the day-to-day affairs of a department with some 120,000 employees and a budget in excess of $25 billion. As Deputy Attorney General, Mark was universally viewed as showing great leadership and deft judgment during very challenging times for the Department of Justice. At the close of the prior administration, he was named Acting Attorney General until the confirmation of President Obama's Attorney General. In 2009, Mark joined the law firm of Kirkland & Ellis, where he engages in a wide variety of litigation and counseling in investigations as well. It won't surprise you to hear that his name shows up on every available list of the leading lawyers in America. Indeed, we are blessed tonight with a speaker who is one of the leading lawyers of his or any other generation, for that matter. Now, as you can see, I wasn't kidding about Mark's resume, but I want to add a few more words about something that actually is really important. Mark and I have been friends for some 20 years now, and I can say that his personal qualities far outshine even his daunting professional achievements. He is just a good man, loyal, faithful, loving, kind, and a genuine and true example of Christian humility. He and his wife are parents to 4 boys who are now entering the wonders of adolescence. I like to remind Mark that there's no better place for good Catholic boys than the University of Notre Dame. He probably can afford it now, by the way. If you ask anybody who knows Mark Filip whom they would most want to counsel them in a time of need, grieve with them in a time of sorrow, or laugh with them in a time of joy, well, he'd be at the top of a lot of those lists. So it's my distinct pleasure and honor to give you my friend, Judge Mark Filip.
Wow, thank you very much for that warm introduction. I'm truly honored to speak here at Notre Dame today, particularly at the Center for Ethics and Culture. I was baptized and confirmed in the Archdiocese of Chicago, as were my wife and our 4 children. Notre Dame is a university with a national and an international impact, of course, but it is also a university that occupies a special place in the heart of Midwestern Catholics. So for a person like me who grew up in Chicago, the idea of speaking here at Notre Dame to such an august group about ethics and justice is indeed an honor. I'd also like to thank my friend Bill Kelly and also Carter Sneed for their kind introductions. Bill and I both had the privilege of clerking for Antonin Scalia at the U.S. Supreme Court many years ago when we were young, and Bill is an enormous asset to Notre Dame. What brings us all together, of course, is the Center's annual fall conference, which this year is entitled The Crowning Glory of the Virtues, Exploring the Many Facets of Justice. Like each of the Center's fall conferences, there are numerous groups of scholars who will explore important aspects of this topic, including justice in science, justice in the arts, justice in theology, and justice and jurisprudential philosophy. When one reads the mission statement of the Center, it speaks of individuals appreciating and acting upon their respective vocations. The English word vocation comes, of course, from the Latin word vocatio, which roughly translated means a calling or a summons. The word vocation, in its initial origin, referred to a person's calling to a religious life, a vocation to be a priest or nun, for example, and the term is still often used that way, particularly in our Catholic faith. But we also broadly and comfortably use the term vocation to mean any calling in life that hopefully will allow an individual to best employ the particular gifts that God gave that person, so as to make the world a better place, regardless of whether that individual serves, for example, as a member of the clergy or a religious order or as a Christian at all. So it rings true to us to use the term vocation, just as it is used in the Center's mission statement, where it speaks of the faculty members' shared vocations as scholars and researchers to expand upon the Catholic moral and intellectual tradition through their leadership in issues of academic and scholarly inquiry. With a recognition of my own vocation and my own limitations, I must confess that it is truly humbling to appear before you now to help kick off the weekend's activities. Generally, you are going to hear from preeminent scholars, truly preeminent scholars, far too many to mention, ranging from John Finnis, whom I had the privilege to listen to many years ago as a student, with something honestly resembling a sense of awe, to Michael Sandel, to Robert George, to many others who are infinitely better read and more knowledgeable than me on any number of issues, including the central philosophical topics of the weekend. If my efforts can add something, I fully confess it will not be as any sort of intellectual or scholar approaching their magnitude. My vocation instead has been as a practicing lawyer in various roles within the American legal system. There are many views and even jokes about lawyers, as there have been for centuries in the United States and before that in England. And in that regard, it may well be true that we have too many lawyers and too much of an obsession with laws in America and not enough of a focus as a society on non-legalistic ways of making our world a better and more humane and just place. Be that as it may, we do live in a time and in a society where law often affects individuals and institutions in critical ways. And so I'd respectfully suggest it is worthwhile to think about ethics and justice as they relate to the practice of law in America. To be sure, there are too many ways in which the practice of law affects our society to attempt to address all of them in any single talk. But one of the ways law can most affect individuals and institutions occurs in the context of legal actions in which the government is an actor and an active litigant. Put differently, I'm speaking of the situation where there is a private individual or entity on one side of the case, and on the other, the government is involved as an active and interested party. The government can be active this way in a criminal law setting, for example, investigating and deciding whether to charge and prosecute a person for an alleged crime. The government can also be active in this way in a civil law setting, for example, litigating a case in which the government claims that a party has committed an unlawful act, such as engaging in racial or religious discrimination, or violating pollution laws, or submitting false claims for money to the federal treasury. In all of these cases, the government is involved and is capable of exercising its unilateral enforcement power against another party. I respectfully submit that interesting ethical questions arise in this space, and that will be the focus of this talk. These ethical concerns directly intersect with what it means to have a legal system in which our government best promotes just outcomes. As mentioned, my professional vocation is to have served in various roles as a practicing lawyer, and many of those roles have been in the service of the federal government. I became a lawyer because when I was growing up in Chicago, the U.S. Attorney's Office there led a very impactful and noted series of prosecutions called Operation Greylord, which helped combat endemic judicial corruption and bribery that were occurring in the state courts of Illinois. That seemed to me like a very inspired job to undertake and a way to help make the community a better place. Later, after law school, I had the good fortune of serving as a federal prosecutor in that same U.S. Attorney's Office. And I subsequently had the great fortune of serving as a federal judge and later helped, along with many others, to lead the Justice Department in Washington, D.C. All these experiences, I hope, afford me some basis to speak thoughtfully about the role of the government lawyer. And in what I hope gives me some balance, please know that I've also found great satisfaction in representing individuals and companies in private practice, sometimes even against the government, an experience I hope that gives me a good basis to see both sides of the ethical questions presented by government lawyering. If these collective experiences have given me something, I hope, to offer you, I hope it will be some useful thoughts about ethics and law, particularly the practice of law in the service of the federal government, after having seen that practice from many sides, both as an advocate and as a judge. So my focus tonight will be a look at some of the ethical issues attendant to government lawyering, both from a historical and present perspective, and how those issues affect questions of justice. Before I get to the specifics, let me please speak for a brief moment about the general. Please know that I will concentrate my comments about the federal criminal and civil justice systems. That's not because the federal system is any more important than the state systems. In state courts, many of the most profound issues of our day get litigated. But I'll focus on the federal system because primarily that's what I know best. Let me also please acknowledge up front at least a few of my potential biases. First, I've spent much of my life, as Justice Scalia would joke if he were here, as a federale within the U.S. Justice Department. I have enormous respect for the women and men of the U.S. Department of Justice, including the attorneys, the administrative staff members, and perhaps most of all for the brave individuals who work in federal law enforcement agencies. I don't think I'll be pulling any punches or shading anything because of those views, but surely you're entitled, in fairness, for me to acknowledge them. At the same time, I now work as a practicing attorney, and at times that involves representing clients who are involved with issues with the federal government, including clients who sometimes are actively adverse to the government. I don't think I'll be shading anything on that basis either, but again, you should know the facts so you can be critical listeners. Finally, by way of background, you should probably know that I believe a fundamental reason that our judicial system works is because we typically have various checks and balances, such that the various actors, including the lawyers for the government and the lawyers on the other sides of the case, have the ability to help deter overreaching by any other actor. That's not to say that such overreaching is particularly commonplace. It is not. But the reason people tend to walk a true line and that the system generally maintains overall balance and integrity is that the checks and balances are there to promote keeping everyone on the right path. And that balance is a fundamental guarantor of our liberties and freedom. Let's start very briefly, please, for those who are not lawyers, on a few basic definitional aspects of the Anglo-American legal system. I will certainly try tonight not to be legalistic. I expect that non-lawyers will come to see that they actually know many of these concepts from regular life or perhaps from books and movies. But it's important that these principles are at least identified a little bit before we move forward. First, our legal system in the United States is envisioned as an adversarial one, in that there are two sides who are allowed to pursue their own self-interests in an adversarial clash. Essential to this model is a neutral decision maker in the form of a judge or a jury, and sometimes both, who render judgment in the case. The parties in the dispute each have the ability to be represented by lawyers who similarly owe, at least in the simplest form, a duty of loyalty only to their respective clients. The parties and their lawyers in this system are envisioned, again, to be adversarial in that they can try to prevail without any duty or expectation, generally speaking, to mitigate their victory if they believe the other side is failing to make the most persuasive argument or point on their own behalf. To be sure, there are minimum norms of legal ethics, and even at times criminal laws enforcing some of them, such that it is both unethical and even illegal, for example, to attempt to bribe a juror or to fabricate documents or to suborn false testimony. Witnesses often swear upon oath to tell the truth, but there are also more earthly sanctions to promote compliance with these basic minimal norms. Entire sections of libraries are filled with books about the jurisprudential underpinnings of this classic paradigm, but for present purposes, I think it's fair to say that the system presumes that the clash of divergent positions, as promoted by vigorous and zealous advocates, and is evaluated by neutral decision makers, will tend best to produce the truth, or at least our best human approximation of it over time. Undoubtedly, every system can have failures, but fidelity to even-handed procedural norms, such as the ability to call one's own witnesses, to cross-examine and question opposing witnesses, combined critically with a neutral decision maker, are seen as vehicles to promote a full and fair airing of issues. And even though there's no way to guarantee in this adversarial system that each side will have perfectly balanced resources to litigate the case, the incentives for a party to marshal some sensible amount of resources to litigate important issues and the general weight of the evidence are seen as generating the truth in the highest percentage of outcomes, at least as compared to alternative systems of justice. Around the world and through the course of history, there have been various alternatives to this classic Anglo-American paradigm. But the most illuminating to discuss as a foil is likely the inquisitorial system of continental Europe, at least as viewed in its classic form. There, the judicial officer is often not a disinterested neutral arbiter, but instead he or she actively investigates, for example, in a criminal case, both the innocent and guilt of the accused, both as an active party and as the fact finder. There is no jury, nor does the accused have any right typically to remain silent, and the fact finder judge both represents the state and questions the subject and other witnesses. Plea bargaining, a subject we'll discuss a bit more later, where the state and defendant agree on a disposition and then present it in one form or another to a neutral judge, is also not part of the inquisitorial system of justice, at least in classic form. Both of these paradigms are oversimplifications a bit because the nuances of judicial systems have changed over time and by particular jurisdiction in both the adversarial and inquisitorial models. But the basic contours of the systems are clear enough for present purposes, and we should now proceed to look at the ethical duties and obligations presented within our system of justice, the adversarial one, in which the parties are typically seen as a check and balance upon each other. As stated in this model, attorneys are generally seen as owing a duty of loyalty to their client, and a fundamental tenet of the adversarial model is that vigorous client-centered advocacy from each side is the best way, combined with fundamental procedural protections, to promote the search for truth. Our focus tonight is on enforcement cases, where the government, through its counsel, seeks to take action against an individual or entity, whether in the criminal justice or civil justice arena. Even within the traditional adversarial model, however, our legal tradition has recognized that government attorneys owe special duties to their quote-unquote adversaries, and perhaps to others as well, that would not adhere to a lawyer simply representing a private litigant. One of the most important of these duties involves, fittingly, the topic of this conference, a duty to seek justice. Government lawyers, particularly when they act as prosecutors in criminal cases, are expected not merely to vigorously advocate, but also, quote unquote, to seek justice. Indeed, the ABA Model Rules of Professional Conduct, in their commentary on the special responsibilities of a prosecutor, describe prosecutors as, quote, not simply advocates, but instead as, quote, ministers of justice. This is lofty language, and at times we struggle to give specific content to it, as I will explain later. But these concepts embody a simple but important premise. At least in description, attorneys acting as government prosecutors are expected to be more than single-minded advocates trying to win. The idea that a prosecutor for the government owes duties beyond simple zealous advocacy stems in substantial part from a recognition of the enormous power that the prosecutor wields. In an enormously influential 1940 speech entitled "The Federal Prosecutor," then Attorney General Robert Jackson acknowledged that, quote, the prosecutor has more control over life, liberty, and reputation than any other person in America. His discretion is tremendous. Justice Jackson, later Justice Jackson, after his service as Attorney General, recounted the enormous powers a prosecutor can wield, and he stated that, quote, while the prosecutor at his best is one of the most beneficent forces in our society, when he acts from malice or other base motives, he is one of the worst. Jackson continued in his speech to call prosecutors to seek balance and fairness in their deeds. The enormous powers of the prosecutor have not dissipated since Robert Jackson, who later served on the U.S. Supreme Court and also as the chief U.S. counsel to the Nuremberg War Crimes Tribunals after World War II, gave his speech. As the then Attorney General stated, because of prosecutors' ability to charge persons with crime, because of the amount of discretion they have over that decision and its ultimate resolution, and because of their substantial insulation from many otherwise applicable oversight mechanisms, the power wielded by government prosecutors is immense. And therefore, the way in which government prosecutors conceive of their roles and responsibilities within our justice system will have immense implications on how that justice system operates. Because of this power, various writings admonish government authorities to, quote unquote, seek justice, or to be ministers of justice. And at times, people have spoken of this responsibility as a quote-unquote quasi judicial role. In looking at the literature in this area over many years, and reflecting on my own experience as both a prosecutor and judge, I believe this admonition, this calling to view the role as quasi judicial, is a very helpful and illuminating one. Let me please take a few moments to discuss the history of the concept, because I think that can shed some light on the important modern ethical issues which confront government lawyers, in which I will discuss shortly. Both the idea of the prosecutor as having a duty to act as a quote-unquote minister of justice and the idea of thinking of prosecutors as quasi-judicial actors emerged in Anglo-American law during the 19th century. The ideas developed concomitantly with each other. My focus this evening is on the latter development, the quasi-judicial role, but I think it's useful to note the intertwined origins of these two concepts, as it suggests, at least historically, that there's been a natural relationship between the ideas that prosecutors best serve as both justice seekers and also best served as judge-like actors, at least oftentimes. In my own research, I found instances of court opinions of prosecutors being described as quasi-judicial as far back as 1865 in England. In the 1865 case of the Queen versus Barons, a prosecuting attorney was chided by the judges of the Central Criminal Court for having taken advantage of a law called Denham's Act, which permitted but did not require prosecutors to provide summations, arguments about the evidence at the close of their cases. In the particular case at issue, the defendant, a Mr. Jules Bayer, lacking representation of counsel, attempted to meagerly defend himself against charges that he had counterfeited 500 notes of Russian Empire currency by calling his own witness and then addressing the jury. His alleged accomplices, represented by counsel, called no witnesses, but simply gave a statement to the jury through their lawyers. Likely in response to Mr. Bayer's resistance to the charge, the prosecuting attorney in the case attempted to invoke Denham's Act to forcefully sum up his own version of the evidence to the jury at the close of the case. But the judges of the reviewing court balked at this act of prosecutorial discretion, largely because, in the context of the case report, it appears that this was already very much a David versus Goliath sort of situation. Taking the prosecutor to task, the court commented that it had always hitherto been the supposition in the administration of criminal justice that the prosecuting counsel was in a kind of judicial position, that while he was there to conduct his case, he was to do it at his discretion, but with a feeling of responsibility, not if as trying to obtain a verdict, but to assist the judge in fairly putting the case before the jury, and nothing more. Elsewhere, the Barons Court stated that, quote, the course of criminal justice should go on as it ought to do, the prosecuting counsel regarding himself really as part of the court and acting in a quasi-judicial capacity, close quote. And I should mention that research suggests that Mr. Bayer was ultimately found not guilty and set free. Cases with very similar language began to crop up in the United States starting in the 1870s, particularly in Midwest states like Michigan and Wisconsin, and usually in situations involving prosecutors exceeding an outer limit of propriety in their pursuit of a criminal conviction. Reviewing courts would step in, rebuke any perceived prosecutorial overreach, and explain that government lawyers, while advocates, are also expected to perform in a quasi-judicial role. These cases sometimes intertwine the reminder about prosecutors' quasi-judicial function with an exhortation to the duty of prosecutors to seek justice, reflecting, as I mentioned earlier, the simultaneous development of the two concepts. The emergence of these issues corresponds to a time of substantial transformation in the American legal system. To take a step back, when I talk about prosecutors this evening, I imagine that everyone in the audience is familiar with the outlines of the role. Prosecutor means an attorney acting on behalf of and employed by the state or federal government. He or she serves the public through their work, bringing criminal charges against the accused, and at least some of the time going to trial. This basic idea of the prosecutor is a fixture of the modern American legal system, not to mention American media stories like Law and Order and other movies of the sort. But this was not always so. At least through the middle of the 19th century, the exact chronology is the subject of some academic debate, which I will spare us all tonight. Prosecutors in this sense did not exist. Very early on, it was not uncommon for victims of crime or those acting on their behalf, such as family members, to privately resolve accusation of criminal conduct against the alleged perpetrator. ideally through, for example, peaceable monetary settlements, less ideally through that well-known euphemism of the time of self-help, which of course ran the risk of creating cyclic violence between partisans of the victim and the accused. In instances where actual prosecutions did occur, it was not at the hands of professional government-employed attorneys, but rather private lawyers who would take these cases on, either at the behest of the victim or their family, or especially later into the century, at the request of a state or local government. It was from this latter model of essentially prosecutors for hire by the government that over time, actual public prosecutors in the modern sense of the word began to emerge. First in urban centers like New York and Philadelphia, and then expanding to cover criminal conduct throughout the state of jurisdiction. This mid-18th century timing also corresponds with the creation of the U.S. Department of Justice in 1870, which led to a permanent corps of federal prosecutors, complementing the rise of prosecutors at the state level. As the 20th century progressed, the resources and roles of these prosecutorial offices expanded for federal prosecutors alongside expansions of institutions such as the FBI and concomitant expansions of substantive federal criminal law. Government attorneys became increasingly professionalized, and one begins to see courts and academic commentators and scholars attempt to flesh out the ethical roles and duties of these prosecutors and government lawyers serving an enforcement role. The idea of prosecutors as having a duty to quote-unquote seek justice in particular was enshrined in two important sources in the pre-World War II era. In a 1935 Supreme Court opinion called Berger versus United States, Supreme Court Justice George Sutherland wrote a now famous passage about the ethical duties of federal prosecutors. The case involved prosecutorial misconduct by a United States attorney seeking to convict the petitioner, a Mr. Berger, of conspiring to counterfeit Federal Reserve notes. I don't know why, but it seems that counterfeiting cases are particularly propitious for historic pronouncements about these ethical issues. Writing for a unanimous court, Justice Sutherland wrote, "The United States Attorney is the representative not of an ordinary party to the controversy, but of a sovereign whose obligations to govern impartially is as compelling as its obligations to govern at all, and whose interest, therefore, in a criminal prosecution is not that it shall win a case, but that justice shall be done. As such, he is in a peculiar and very definite sense the servant of the law, the twofold aim of which is that guilt shall not escape nor innocence suffer. He may prosecute with earnestness and vigor, indeed he should do so, but while he may strike hard blows, he is not at liberty to strike foul ones, and it is as much his duty to refrain from improper methods calculated to produce a wrongful conviction as it is to use legitimate means to bring about a just one." 5 years later, Robert Jackson, as Attorney General of the United States, as previously explained, delivered a speech to the second annual Conference of United States Attorneys in Washington, D.C. That speech remains, over 70 years later, one of the seminal expressions of the duties of the government lawyer. In that speech, Robert Jackson echoed Sutherland's themes as he stated, "The qualities of a good prosecutor are as elusive and as impossible to define as those which mark a gentleman, and those who need to be told would not understand it anyway. A sensitiveness to fair play and sportsmanship is perhaps the best protection against the abuse of power, and the citizen's safety lies in the prosecutor who tempers zeal with human kindness, who seeks truth and not victims, who serves the law and not factional purposes, and who approaches his task with humility." In the wake of Justice Sutherland's admonition in Berger and Robert Jackson's pronouncements, courts fleshed out some of the ethical duties attendant to the role of prosecutor to give more content to these certainly broad terms. Prosecutors were expected to provide and not to suppress from the defense or the judge or the jury evidence in their possession that would show an accused was actually innocent. Prosecutors were expected to provide and not to suppress from others evidence in their possession that might suggest witnesses against the accused were biased against the accused or had incentives, such as promises of immunity, to testify favorably for the government. Model codes of professional ethics also embrace the ideas of government enforcement attorneys having duties higher than mere zealous advocacy, instead expecting them to consider their roles, again stated as ministers of justice. Today, the principles set forth in Justice Jackson's speech and the opinion in Berger, and especially the unique role of government prosecutors to seek justice, have become part of the fabric of the U.S. Department of Justice. Every federal prosecutor has read, or at least has been made aware of these writings. They have been codified in U.S. Department of Justice guidelines, and the principles enunciated in them are expected to guide prosecutors in their exercise of discretion when handling matters on behalf of the department. In ensuing decades, various influential commentators have also explored how this quasi-judicial role should be understood to apply when prosecutors, for example, dispose of 90% of their cases through plea bargaining instead of trial. Other scholars have expressed concern about the lack of specific definition for these historic admonitions to act as quote-unquote ministers of justice, and have suggested specific canons of conduct and behavior for prosecutors. These issues are important ones because a call to acknowledge special responsibilities as a government lawyer cannot properly be understood as an invitation for each government attorney to act upon individual and purely subjective views of fairness, as I will discuss more shortly. In an urban U.S. attorney's office, for example, there may well be over 100 prosecutors. There cannot be 100 systems of justice in that community where the outcome for any defendant depends principally on which prosecutor is assigned to the case. Judges are not expected to be free roaming agents of their personal conceptions of fairness, and we as a legal system can fairly ask the same of government lawyers. The details of these specific canons of conduct, however, are likely too involved to explore in a setting like the one we have here. What is more productive, and I hope more interesting, is to step back and look at some of the more general dynamics at play here and how they intersect with our ideal of an adversarial system of justice that promotes reasoned and balanced outcomes through checks and balances and evenly matched parties. So given that history has long recognized that there are certain special duties and ethical norms for government lawyers, it is worth considering certain settings that have not been the subject of particular attention concerning these ethical norms and how justice can be promoted by thinking about them. As variously stated, I believe justice is best promoted by a system of checks and balances to ensure that litigants and lawyers in any case do not assume that they quote-unquote know the truth. Checks and balances are important in the rare case where there is an actual bad actor in the system. However, they're also important to help us all, even when acting upon our highest motives, from proceeding on what we sincerely perceive to be noble ends, to consider or to justify shortcuts that threaten the integrity of the system, particularly over time when taken in any sort of repeated and therefore corrosive application. This idea of checks and balances is fundamental to the notion of an adversarial system of justice. So in thinking about promoting justice in our system, I'd respectfully suggest that government lawyers can productively consider whether they're acting in a quasi-judicial function and with an open mind in settings where the adversarial check and balance tends to weaken structurally and the idea of access to a disinterested neutral decision maker is practically pressured by the circumstances at hand. To give more context to this dynamic, consider please a situation where a prosecutor is investigating a series of 10 or 12 generally similar bank robberies that have occurred over the last several months. There are some general similarities. The robber is a medium-sized white male with a disguise who claims to have a gun, but no telltale signature that makes it obvious that the robber is the identical person each time. The robberies are occurring across a general area, the greater Los Angeles area, for example, but not in a single specific geographic cluster. It is unclear in this setting whether this is a one-man crime spree, which sometimes happens, or instead is the work of a series of robbers, sometimes copycat robbers, as often occurs too. Assume now that a white male is apprehended with a gun after one of these robberies. He admits readily to 2 of the other robberies, but denies committing the other 8 or 10. In this setting, the prosecutor has tremendous leverage. He can assuredly charge the robber with the single robbery that prompted the suspect's apprehension, as well as the other 2 robberies to which the man has admitted. These 3 robberies likely will produce a sentence of several years imprisonment in the federal courts, probably somewhere between 8 and 10 years imprisonment. And the sentence imposed will actually be the sentence served, because our federal system largely tracks truth in sentencing concepts. The prosecutor can also assuredly charge the defendant with a firearms offense, a federal firearms offense for using a gun in the course of a robbery, the robbery that was the subject of his arrest. That is an independent criminal charge in the federal system that carries what is called a mandatory minimum sentence of 5 additional years imprisonment. All of the pluses and minuses of mandatory minimum sentences are beyond the scope of this talk. Many thoughtful articles have been written about them, and there are both merits and demerits to mandatory minimums. The sentences are enshrined in statutes enacted by Congress, and I certainly respect that in our democratic system, Congress has the authority to weigh the attendant policy choices and enact such laws if it deems them necessary. But what is important for present purposes is that the judge, who normally enjoys substantial discretion in fashioning a just sentence, has none of that discretion concerning any sorts of these firearms offenses. Instead, the discretion remains with the prosecutor. In addition, under the federal criminal laws, if the prosecutor elects to charge the defendant with firearms offenses for the other 2 armed robberies that he has already admitted, the sentencing regime applicable by law mandates that the judge will be required to sentence the defendant to 2 additional consecutive terms of 25 years imprisonment. So put differently, if the prosecutor elects to indict the defendant on those 3 firearms charges, and that decision is often viewed in many U.S. attorneys' offices as a highly discretionary one for the government, the defendant will face a mandatory sentence on the firearms charges alone of 55 years imprisonment. That is, for most people, akin to a life sentence, regardless of whether they have any prior criminal history or prospects of rehabilitation, and there will be no room for any judge to impose any other result. In deciding whether to charge those additional firearms offenses, a prosecutor will often be asked to consider whether the defendant has fully accepted responsibility for his past crimes. There may be, not always, but often, substantial pressure on the attorney, perhaps from the media, perhaps from other forces, to declare that all of the prior armed robberies have been solved because this robber committed all of them. The prosecutor will surely press the defendant's lawyer in plea bargaining discussions for the defendant to accept responsibility for all of the crimes. The prosecutor may take the position that he or she will not make a plea bargain unless the defendant admits that he committed all of the other prior robberies, which he presently denies committing in substantial part. If the defendant does admit them, the prosecutor may be willing to bargain away the additional gun counts and the corresponding 50 years of mandatory minimum sentences. If the defendant does not admit them, the prosecutor may charge the defendant with all of the robberies and all of the corresponding gun counts, such that best case, the defendant can expect to get probably about 65 years imprisonment, even if he is convicted of only the charges for which he has confessed and otherwise acquitted on charges relating to the other bank robberies that he denies committing. I do not offer this example to suggest that charging these multiple firearms offenses is always inappropriate. I do not believe that justice should be confused with leniency. Sometimes the 2 concepts lead to the same outcomes, but sometimes they do not. because sometimes a just outcome is a severe one. Instead, I offer this example as a situation where a prosecutor, I'd respectfully suggest, must appreciate that the normal checks and balances of the adversarial system and the benefits they afford the defendant, the government, and the public overall have largely eroded. If the defendant comes to believe that his choice is, on the one hand, admitting to crimes he didn't commit, or on the other, facing an effective life sentence, the defendant might well admit to the other crimes whether he has admitted them or not. That is ultimately not in anyone's interest. The crime wave will presumably continue, and the defendant may serve a lifetime in jail when a substantial sentence, likely one of 10 to 15 years imprisonment, would otherwise have been deemed sufficient. In this setting, I think it is well worth considering the contours of the prosecutor's quasi-judicial role. Here, the prosecutor in many respects has become both judge and prosecutor. The decision whether to charge the 3 firearms counts, that is, the firearms counts on the admitted bank robberies, is in some respects a discretionary decision within the power of the prosecutor to impose a life sentence. So the assessment of whether the defendant should be understood to have committed the other several robberies, a decision made with the prosecutor functioning quite a bit like a continental prosecutive magistrate, both accumulating the evidence and evaluating its consequence for the ultimate disposition of the case, truly has the hallmarks of a judicial act. I take no existential quarrel with the prosecutor functioning in that role here. That is largely inevitable, it seems to me. But I would respectfully suggest that we all benefit from the prosecutor envisioning his or her role here as essentially judicial, with all of the attendant moral duties to attempt to be as dispassionate, neutral, and uninfluenced by external pressures as is humanly possible. This situation is not a unique, niche-like dynamic contrived in the context of our hypothetical bank robber. It exists in even starker forms in the context of a prosecutor's decision whether or not to invoke the death penalty, in which acceptance of responsibility concepts might concern the defendant admitting to other unsolved homicides, or perhaps agreeing to testify that another individual, whom the prosecutor strongly believes but is not certain also participated in the murder, was indeed a collaborator in the homicide. I did not offer this homicide example in the first instance because capital punishment cases obviously invoke other moral and ethical questions, and questions about justice which complicate the more basic point I'm trying to convey. But the issue of the quasi-judicial role and the attendant moral duties at a minimum remains the same. The dynamic also exists in other situations less stark than capital punishment scenarios. For example, in our system of federal laws, various companies convicted of fraud, for example, can be subject to what is called mandatory debarment from participating in any business activities involving federal funds. For many companies, including some of the largest in our nation, such as defense contractors or healthcare and pharmaceutical companies, a potential negative outcome in one of these cases, accompanied by mandatory debarment, is truly akin to a corporate death penalty. Imagine a defense contractor who cannot do business with the Pentagon, or a healthcare company that cannot participate in Medicare-related business. In such a setting, it is fairly commonplace for a company to have indisputably committed certain infractions, but to dispute that it has committed others. Some of these infractions in our modern regulatory state can even be strict liability offenses, in which the government is not required to prove that the defendant intentionally engaged in any wrongdoing. The simple fact of the misconduct alone is enough to constitute the offense. In that setting, the government has enormous power to force charges or agreed fines and sentences upon the corporate defendant, because failure of the defendant to accept the government's offer, which allows for the debarment issue to be negotiated to a successful resolution, will trigger the specter of the functional extinction of the company. Here, as before, the government lawyer is effectively operating in substantial part outside the confines and the checks and balances of the orthodox adversarial system, even where the defendant has enormous resources to fully engage the adversarial process. Again, that is unavoidable in our system. I take no quarrel with that fundamental dynamic, but that very unavoidability suggests that duties to operate in a quasi-judicial manner are particularly worthwhile to keep in mind, because the prosecutor is again functioning as both advocate and judge in both the prosecution and the sentencing because of the circumstances at hand. In stating that a prosecutor likely enhances the cause of justice by thinking about his or her quasi-judicial role, I would please offer that my suggestion about the importance of appreciating a quasi-judicial role is not a call for some gauzy duty to quote-unquote be fair. Certain commentators have appropriately stated that some literature in this space elides past the questions of what fairness and judiciousness means. When we ask a government lawyer to appreciate his or her quasi-judicial role, I think it's worth remembering that the idea of a judicial mindset is not a unique concept. It critically involves respect for precedent, such that outcomes embody collective wisdom and tradition, not just personal preference or will, a desire to promote equal treatment under the law amongst similarly situated individuals, and a recognition that rigorous analysis of positions, as opposed to proceeding by fiat or edict, promotes principled adjudication of issues over time. Being judicious does not necessarily mean being lenient, any more than being judicious necessarily means being tough. People who serve in judicial roles do not speak about whether they are lenient or tough and appreciate that in some instances each is fully appropriate. But a quasi-judicial role invites an open-minded detachment and a concomitant commitment to exploring both interested parties' positions. Those attributes seem particularly apt for a government lawyer when they find themselves in a situation where the checks and balances of the adversarial system and ready access to having disputes be aired and resolved by a judicial neutral are diminished or perhaps even effectively extinguished. A second area I'd please like to focus on concerns one of the most cherished principles of good prosecutors, the principle that they have no interest in convicting an innocent person. From time to time, typically in an overwrought movie or television program, you'll see a prosecutor or law enforcement agent portrayed to express some variant of the phrase that, quote, anyone can convict a guilty defendant. It takes someone truly talented to convict an innocent one. In my experience, you will never hear such statement in a responsible prosecutor's office, not from the prosecutors nor from the federal law enforcement agents who are even more foundational in our system, because they all broadly find the idea of imprisoning the innocent so profoundly antithetical to their worldviews that the subject should not be spoken of even in supposed jest. Nonetheless, because of the gravity of the issue, it is worthwhile pausing to think about when the quasi-judicial mindset we've been discussing is most important to the application of this fundamental principle. In that regard, in our system of justice, sometimes statutes are passed which anomalously dispense with the need for the prosecutor to prove that the defendant intended or even knew of the illegality of his or her actions, or hold an individual defendant criminally liable without further proof because of some misconduct on the part of others which has occurred, for which the defendant might have had the power to intervene and stop if he or she had been aware of it. These sorts of crimes are called strict liability crimes, and they are, as you would expect, not the norm within the traditions of the Anglo-American jurisprudential system, where ideas of bad intent and the power of free will to choose or avoid criminal misconduct are generally seen as fundamental. It is also worth noting that strict liability crimes can lead to imprisonment, so they're not petty offenses without substantial real-world consequence. In a setting where a strict liability crime potentially can be charged, the paradigm of the adversarial system of justice, with its checks and balances, is substantially diluted in practical terms. The issue most likely to be the subject of dispute in these settings would normally be whether the defendant intended or knew about the risk of a bad action occurring. Put differently, the defendant can normally ask a judge or a jury to determine if he or she had bad intent or at least knowledge of an impending bad act. That question can be the subject of meaningful and real dispute, so the check and balance of the neutral decision maker gives both the defendant and the government attorney leverage. But in a strict liability case, the power and authority is effectively with the prosecutor, all of it in most instances. The idea of a trial or a neutral decision maker is in many respects besides the point, because the only real open issue is whether the prosecutor will elect to charge the crime and seek to punish the defendant. Again, my point tonight is not to posit an alternative reality in which prosecutors did not face such dynamics. However, in this important setting where individuals' personal liberty can hang in the balance, it is worthwhile, I'd respectfully suggest, for prosecutors to consider whether their quasi-judicial duties are even more robust than usual, because the importance of judicial neutrality is substantially diminished. Therefore, the judicial values of respect for precedent, of promoting horizontal equity as opposed to outcomes driven by personal view, of disciplining oneself even more than usual to consider both sides of a question and not to advocate internally for a particular result, are more important than ever. You will note that all of the examples we've been discussing so far have concerned criminal prosecutors. The criminal setting is often illuminating because the stakes of a government action are often so high. Loss of liberty, or perhaps even life for a human being. But my arguments are not limited to the situations where the government is acting as a prosecutor. The dynamic we've discussed, where circumstances align to put pressure on the system of checks and balances that the adversarial system of justice is predicated upon, are not limited exclusively to the criminal arena. In some instances, for example, criminal and civil enforcement authorities work side by side in a case. If the defendant is an individual, there can be a substantial difference, principally in the sanctions that those criminal and civil enforcement colleagues can and do seek. The criminal prosecutor is most likely to seek potentially to put the defendant in jail, whereas a civil enforcement attorney is going to seek an injunction governing future conduct or even more likely civil damages. But in some situations, this dichotomy does not exist. If the subject of the enforcement action is an entity, for example, then the sanction that both the criminal and civil enforcement authority seek to impose is typically a financial one. That the prosecutor seeks to impose a quote-unquote fine on the one hand, and the civil enforcement attorney seeks to recover quote-unquote penalties and damages on the other hand, is in many sense simply a matter of semantics. So to the extent a civil enforcement authority confronts the sort of scenarios we have discussed tonight, the quasi-judicial obligations analyzed above would seem to be appropriately considered. Some individuals, largely people who have not practiced in government settings, have expressed skepticism that quasi-judicial duties should extend to civil enforcement attorneys as opposed to criminal prosecutors. And there are substantial reasons, in my opinion, to question that view. First, the seminal expressions of the duties of government lawyers, ethical duties, apply broadly based on the notion that a government taking action, or even considering taking action against one of its citizens, owes a duty to operate in a substantively just manner. Thus, for example, literally inscribed on the rotunda outside of the Attorney General's office at the U.S. Department of Justice in Washington, D.C. is the following inscription. Quote, "The United States wins its point whenever justice is done to its citizens in the courts." Close quote. The inscription makes no difference, no distinction between civil and criminal cases. History credits the origin of that phrase to Frederick Lehman, who served as Solicitor General of the United States from 1910 to 1912. The Solicitor General is the main attorney for the United States in the Supreme Court. He or she has a team, a very elite team of a couple dozen attorneys who also represent the United States in the Supreme Court. And some of the faculty here have served in that role. But the docket of the Solicitor General and his or her assistants include numerous civil cases as well as criminal ones, just as Lehman's did when he articulated that famous phrase. In addition, in at least some instances, there is judicial precedent strongly reinforcing the view that quasi-judicial duties of government attorneys are best applied in both civil and criminal settings. To take one prominent instance, in a 1990 case from the U.S. Court of Appeals for the D.C. Circuit, which is one of the most distinguished courts in the United States, a civil attorney representing the federal government challenged the premise that government attorneys should not be held to higher standards than attorneys for private litigants. Even though the case was moot for purposes of adjudication, which means that the issues that brought it to the court no longer existed, the judges on the court specifically wrote to vigorously reject the government's contention about its ethical obligations in civil cases. The panel of judges in that case was a particularly distinguished one, including two former high-ranking Justice Department leaders, the Honorable Larry Silberman and the Honorable Raymond Randolph, as well as Chief Judge Abner Mikva, who had served as chief counsel to the president in addition to his various years of other government service. In the panel's opinion, the judges quoted from the Supreme Court's classic teaching in Berger versus United States, where the Supreme Court explained that a government attorney is, quote, the representative not of an ordinary party to the controversy, but of a sovereignty whose obligation is not that it shall win a case, but that justice shall be done, close quote. The D.C. Circuit panel noted that while the Supreme Court in Berger was speaking of prosecutors, to the court's knowledge, no one had ever suggested that the principle does not apply with equal force to the government's civil lawyers. And the court continued to note that, quote, in fact, the American Bar Association's Model Code of Professional Responsibility expressly holds that, quote, a government lawyer in a civil action or administrative proceeding should proceed with higher standards than private lawyers, stating, among other things, that government lawyers have a responsibility to seek justice. Let me pause, please, before concluding to make one important point. My arguments about the applicability of heightened importance of a quasi-judicial mindset for government attorneys, I hope, are not legalistic, in the sense that this duty must be necessarily the subjects of lawsuits or judicially enforceable rules. Rather, it is an invitation, respectfully, to lawyers involved in our justice system to consider these duties and to consider how best they can be fulfilled. Many of these people serve in different roles at different points in their lives. Often they first serve after law school as law clerks in the judicial branch, and then they variously serve, among other roles, as defense attorneys and as prosecutors, sometimes in multiple succession, and then sometimes serve as professors or as judges as well. They appreciate that they may not always wield government authority, and that even if they do, their children and grandchildren almost surely will not, such that we all have a substantial shared interest in having a fair system that promotes just outcomes over time. In my experience, first-rate government attorneys, just like first-rate doctors or first-rate accountants, are interested in thinking about whether their professional actions best contribute to the public good and to just outcomes. So even though no one can go to court and try to enforce an ethical norm merely because it is written on the rotunda of the Justice Department headquarters, government attorneys still deeply internalize ethical norms, in my experience, that they believe to be true. And I respectfully suggest that it is worth all of us, including scholars and practitioners, to consider these issues because they involve matters of substantial consequence for our citizenry and our society overall, not just the individuals serving as attorneys for the government today. In closing, let me please thank you for the opportunity to speak here tonight. I've had the honor of serving in different roles in our system, and as the years go by, I increasingly come to appreciate two things. First, the older I get, the more I appreciate the checks and balances in our justice system that deter overreaching by any side in a case. And second, I appreciate the value of focusing on ethical issues related to the practice of law, because thinking about those internal ethical norms helps all attorneys to be better citizens and actors in our system of justice. I hope my comments tonight have been a small contribution to that dialogue, and I'm truly honored to have had the chance to speak with you. Thank you.
Thank you, Mark. We have time for questions. There's two microphones on the ground floor and then a microphone up top, so feel free to line up. And while people are thinking about questions, I'll begin with one of my own. In two of your roles, you have confronted these questions from different perspectives. And one involves maybe an excess of discretion to do justice, and the other involves maybe not enough discretion to do justice. And I'm thinking first, as the Deputy Attorney General, for the people in the audience who might not be aware, the management role includes channeling the prosecutorial discretion at a general level of the United States attorneys. And there have been long controversies and ebbs and flows in the degree of discretion that the department institutionally will permit the U.S. attorney's offices to exercise in making their charging decisions. And basically it comes down to you're supposed to charge as much as you think you can prove, as much as you think you can convict. And in your role as Deputy Attorney General, Mark, you had to adjust this guidance to deal with a situation where prosecutors were faced with the possibility of proving so much that they believed it was an injustice, or deciding not to prove as much as they could to avoid what they perceived as an injustice as a matter of discretionary policy. So that's one way. I mean, how did you think about that problem in the real world when you had to confront it? And the other is, as a judge, you don't have the power, actually, to decide what is charged. It's up to the government. And so how did you deal with the situations as a judge where you perceived the government either to be undercharging or overcharging, because Congress has made policy decisions that aren't yours to disrupt? And after that, you can call on people, even without that.
Thank you. There's at least a couple questions in there. The easiest is probably in terms of execution as a judge. Judges are bound by the system that they operate in. They're bound by the statutes that Congress has passed. Oftentimes, there are situations where the prosecutive office has enormously more discretion than the judge does. Judges on a court can have a dialogue with the government in that setting. The community at large can have a dialogue about that setting. Some districts think that the system, the discretion being exercised by the U.S. Attorney there is perfect. Some systems think it's not. It differs in different parts of the country. But for judges, they are largely locked in. The only way that you would try to move around that would largely be an inappropriate one, you know, to undermine what you believe to be the truth or interfere with the authority that our system has afforded the prosecution there. So as a judge, you not infrequently have to render judgments that you would not personally, you know, if you decided everything in the world that came in front of you, would personally do. And that's part of when people talk about the humility of being a judge, part of what you have to come to accept. In terms of dealing with discretion in the Justice Department, the hardest issue, which is similar to the issue you're talking about, the hardest issue I think deals with that discretionary principle about what to charge given the disparity of districts in the United States. So, for example, if you go to the District of Arizona, literally 93, 94% of the cases year after year are going to either be narcotics offenses or immigration offenses or both. If you go to the Dakotas, half of your docket might be what otherwise would be state cases that occur on federal lands. So the folks in Arizona or San Diego or New Mexico are going to tell you, we simply cannot abide by the rules that you have for other parts of the country because our system will break down if we charge the most onerous offense in each case that we have before us. There aren't enough cells in the courthouse, there aren't enough judges in the courthouse, and so people try to promote, at a minimum, equal treatment within jurisdictions, even if it may not be feasible to have complete uniformity nationwide. I'll tell you a brief story for 20 seconds. One of the most awkward things I ever had to do as Deputy Attorney General was go to Arizona to announce that Congress had just awarded them 30 new prosecutors to prosecute immigration crimes in the state of Arizona. And every single judge in that district lined up to tell me that that was a nightmare and that they were horribly, horribly, you know, wronged by having all those prosecutors come because there were no more judges and there were no more marshals and sheriffs. So it's a problem. It's a practical problem in different parts of the country, and you try to promote uniformity by jurisdiction. Sir?
Yes. Good. Ryan Nash from UAB. Thank you for a very good talk. One of your points, I liked much of what you said. One of your points was on the role of the prosecutor, making a distinction between it not just being an advocate, being a civil minister of justice. But I wonder if this may denigrate the role of advocacy and may also give too much of a monolithic view of justice. Over the next couple of days at this conference, we'll hear a great diversity of views of what justice is. So I wonder, could a prosecutor not just be a minister of some universal form or ideal of justice, but really be an advocate, really still in the role of advocacy, but this time for the state, the civil magistrate, or the court? I mean, even the examples you gave in giving leniency or not convicting the innocent really are reflecting the advocacy of a view of justice that's the prevailing view of justice of this current civil magistrate. So to try to consider this, I think, can you imagine a case where your view of justice would demand a certain course of action, but the prevailing view of the civil magistrate would demand another course of action? And I'm going to speculate and say that most prosecutors are going to yield, just as you mentioned judicial yielding, to the prevailing view of the civil magistrate, which really makes the prosecutor an advocate for the civil magistrate. So I don't know if the views are all that different. So I think.
If you're a prosecutor in a courtroom as an officer of the court, you do have to accept the rulings of the court. So if the court rules a particular way, you have to accept that. Does not mean you have to accept it in the final sense that that is either your belief about what a just result was, or that in some instances at least that that's your final opportunity to be an advocate. You can seek review in an appellate court and advocate a position to a higher tribunal. Ultimately, each of us owes a duty to the system, whether it's the appellate court or the Supreme Court, whatever the final ruling is, that attorney will be bound by it, the parties will be bound by it in our system. To live to it in our system, but that doesn't typically mean in the setting of a particular courtroom that a prosecutor, if for example the person believes in their case and they believe that they're trying to prove the guilt of that particular individual, they will be a zealous advocate in that regard, and they will at times object to rulings of the court, and they will at times seek review from another court of them. Sir?
Thank you, and thank you for your remarks. You pretty much answered my question when you talked about how constrained a judge is by precedent, by the will of the legislature. But with regard to the ethical duties of the judges and the prosecutor, do you think that they're simply different, or do you think a prosecutor in some sense has a higher ethical duty to pursue justice?
I don't know that I would order them in terms of who has a higher duty to pursue justice. I think they have different roles in our system. A prosecutor who believes that someone is innocent shouldn't charge the case, whereas a judge who believes that the case of the government is not progressing to be appropriate has an opportunity at the end of the case, if the proof has failed, to dismiss the case, but should not until the appropriate juncture do that. So I think each person has a duty in the system to perform their role and thereby hopefully promote just outcomes within the system. Maybe if I understand your question correctly, I do believe prosecutors have greater ability than anyone else in the legal system to quickly and efficiently affect what would ordinarily be understood to be just outcomes. If you believe that a particular individual is innocent and you explain that, that will almost always be the end of the matter. If someone says that they believe that an otherwise perhaps technically legally correct sentence in a conspiracy setting, for example, that might put an 18-year-old kid in jail for the rest of their life, is too severe, and that individual should receive something substantially less than that because they're going to be a witness or they're going to otherwise cooperate in the case, that outcome is typically accepted. There are reviews of it. It's not each individual person deciding what they want. But to answer your question, and I tell this sometimes to students when I've had the good fortune to teach in law schools, if you care about constitutional rights, if you care about just outcomes, if you care about protecting the innocent, you can further those goals as a defense attorney, as a public defender, to be sure, but you can do that even more efficiently, and it's essential that you do so if you're a prosecutor. So they have enormous power in that regard. Sir?
Hi, Dan Sportello from Notre Dame Philosophy. I know almost nothing about the law, which should prevent me from asking this question, but it won't. Naively, in my mind, as someone who knows nothing about the law, I think, how do you get promoted as a government lawyer? Well, you win cases, right? This seems to be at odds with the ideal you're promoting. Is there a way to restructure incentives for government lawyers to promote the ideal you're suggesting?
It's a great question. It's one of the greatest responsibilities that people in leadership have in any prosecutive office. You have to, it is always easier to say that you should take the more severe position in a prosecutive office. No one will ever question you for being hard-nosed. And it's a lot to expect a 26-year-old young adult to take a position contrary to a stated atmosphere in their office. That's true whether you're in the U.S. Attorney's Office in any particular district or you're in a district attorney's office, whatever the case may be. So one of the most important things that leaders can do in a prosecutive setting, and this is the people who will tell you this with the greatest passion are police chiefs and FBI senior people, even more than lawyers, is to make clear to people that it's okay, it's appropriate to say, I'm not sure we have the right guy here, or I'm not sure we really need to charge that, because what you're talking about, you must convey to people both in word and in action that, it is not necessarily a good thing to say I convicted more people who are serving more months in jail than any other prosecutor in this office. People are not, generally speaking, in a private setting, if you're a company, and this is an oversimplification, making more money for the shareholders year over year is always good. If it's a prosecutive office and you're putting more people in jail for longer periods of time forever, such that the logical consequence of that is, God willing, if we just live long enough, every other person in the world except us will be in jail. That can't be the right answer. So it's the duty of senior people to make clear exactly what you're talking about.
That touches on one aspect of this quasi-judicial role that I was thinking about. I was asking, how is the lawyer or the prosecutor like the judge, and how different? And one thing that I thought of is the judge has to convict only when there's no reasonable doubt that the accused is guilty. And so I thought, well, is the difference that the prosecutor is, when he's making his quasi-judicial decisions, entitled to a lower standard? Of course, as you pointed out, if his judgment is that the fellow is innocent, I think when we say probably innocent, he shouldn't prosecute for a variety of good reasons. But is he entitled to a lower standard? Does he have to think that the person he's trying to convict is guilty beyond a reasonable doubt? Or can he think, I think he probably is, and so I'm going to make my best case and let his defense attorney make his best case with all the help that I'm obliged to give the defense attorney? In other words, can I prosecute somebody just because I think he's guilty? Or is that why we have to say, part of the reason why we have to say quasi-judicial?
It's a great question, and it touches upon one of the great areas of grayness, if you will, in the sort of prosecutive canon of ethics. As a legal matter, you can go, for example, to a grand jury and ask them to indict upon the basis of probable cause. So 51% you think the person is doing it. One is allowed to take the view that the grand jury has decided, and the jury will sort it out. And they get a lawyer, and we're just going to go to battle, and you know, it'll all be sorted out by a higher authority over time. There is also an ethic, and this is the ethic of the U.S. Justice Department, that more is required, that people must have proof beyond a reasonable doubt in their mind of the accused's guilt to indict and proceed. Where it gets even grayer still is you may know indisputably or close to it within sort of the bounds of human knowledge that someone is guilty, but there may be a failure of proof to be sort of clearly proof beyond a reasonable doubt. For example, if it's undisputed that the law enforcement agents unlawfully obtain certain evidence, such that, for example, 5 pounds of heroin that were in someone's car with their fingerprints all over it have been suppressed under the law. You may have a strong case, but not perhaps manifestly proof beyond a reasonable doubt after that suppression ruling has been issued. Generally speaking, people are of the view that if an error has occurred, you know, for example, by the agents having, and this doesn't often happen, but having screwed up and unlawfully obtained that evidence such that the evidence is suppressed, the facts, the sort of moral fact of that individual's guilt is sufficiently clear that the government will try the case, even if it's, you know, 70-30, 60-40, that the person will be convicted. So it's a great question. It's the kind of thing that people, it gets even more interesting as you apply it over time in the real world. Sir?
I'm also not a lawyer, so this might be a really basic question, but we're 2 days removed from the elections, and so this kind of popped in my head. With you talking about the quasi-judicial role and the amount of discretion that prosecutors have, it struck me that at the state level, we elect our state's attorneys, where at the federal level, you know, they're appointed, and there are issues, it seems to me, with both of those ways of choosing them. You know, a friend of mine was just elected as state's attorney, and you know, it's a partisan position. I mean, and so there's obviously some issues there, whereas at the federal level, and I'm from Illinois too, we've definitely in the past, I've heard some grumblings about different appointments of prosecutors. So I wonder if you might comment on that a little bit.
Each system has strengths and weaknesses, and there's no guarantee just by virtue of the system that you're going to get it right in any particular instance or that you're going to get it wrong. To me, that sort of shows the heightened importance of thinking about ethical questions, both for the chief individual in that office and also for all the people who come through prosecutive offices. There's enormous turnover in prosecutive offices in the United States. That can either be a cause for concern because people are going to be opportunistic and not appreciate their role, or it can be a great opportunity to instill these ethical concerns in all sorts of people who subsequently are going to become things other than prosecutors, whether they become professors or whether they become private practitioners, and hopefully if they become, I mean, if they choose, you know, parents, they'll convey that to their kids or their nieces and nephews. So hopefully, I guess what I'm trying to say is the system can't guarantee an outcome, but that's why I think the importance of thinking about these questions so that people can have them top of mind. And it's important to do it early because you can't be on the job 2 years before you figure out that it's okay to say that the harshest outcome is not the only outcome we should consider. Sir.
First of all, thank you for an insightful and informative and only slightly confusing for an undergraduate reflection. My question is also somewhat concerning elections, but more for other public officials, specifically with regard to negative campaigning. is there any sort of ethical standard among elected officials with regard to negative campaigning, what sorts of negative attacks they are willing to pursue against their opponents, and is there any sort of professional standard, not just personal, or any way to enforce that on a wider scale?
You mean for people running in prosecutive elections?
No, more generally, like people who swear to uphold the public good, how do they live that out in how they pursue their campaigns? Because it seems like that is another instance of where we, the people, act as judges between two adversarial positions.
Right. I've never run for a political office, so I can't purport to be an expert on this. I am quite confident that there is no prohibition generally on people advertising negatively about political opponents. What is an interesting question, and I still don't know the answer to this one, but what I would think would be a fascinating question for people like that gentleman's friend who's just been elected district attorney, is there some ethical norm that applies specially to lawyers that would prohibit or counsel against running negative ads based on, for example, only 95 people have been convicted this year, and when the other person was there, they convicted 150, which would imply that the idea that it's simply an affirmative good always and everywhere to put more people in jail, when that can't always and everywhere be true. That I think would be a fascinating ethical question. I don't know the answer to it just because I've never been a state prosecutor since I was a law student, and I've never run for any political office, so I just don't know the ethics on it. But that I think would be a fascinating legal question.